Looks like it's 10:30, so we can get started. Thank you, Christy and Teresa, for being here today. So Christy and Teresa are going to be our facilitators. Christy Cork is a specialized consultant in healthy workplaces with WSPS, and Teresa Bowen is a health and safety inspector with MLITSD in the London area. So I'll leave it to you two ladies to get things started. Thank you.
Thanks. Perfect. Thank you, Tanya. Yeah, so I'm just going to get started and go through a few housekeeping things, but welcome everybody, and thanks to those of you that chimed in the chat with where you're located and different industries and sectors that are represented on our session today. It's always nice to see who we've got joining. So I'm located down like St. Thomas area, just south of London, and Teresa's London area. So, you know, we've been working together on these 3 safety connections. So this is part 3 of a 3-part series. The first one really focused on the legislative requirements for workplace violence and harassment. The second session focused on doing workplace violence risk assessments. And now we're talking about investigations. And we're going to get into sort of the nitty gritty, what's the legislation. That's why we've got Teresa on the call today, because she's the expert as far as, you know, what do employers have to do? How is it interpreted? All of those things we're going to be asking Teresa about. But I'm going to go through a few housekeeping things first. So we do have a quick disclaimer slide, just that our images are all through Getty and we do pay for them, so we're not stealing. This is a demographics collection survey. We'll pop this up, or we'll have a link to this also later on, so you don't need to do it right now and get super distracted. But ideally, we do want to know who's joining and who's using these free safety connections, because it does help us sort of determine, you know, where we should be focusing our energy and time and resources, what sectors are represented, those types of things, and really just to get some feedback. So again, when you have a moment, and the function number is listed there, we'll post that again towards the end as well. So there's a few things about these safety connections. So we did have almost, 100 participants register for today's session. So for that reason, we do mute all microphones except the presenters, because the background noise can be very, very distracting. We do recommend you using computer audio, and we don't have cameras for all participants. So you get to sort of sit back and let Teresa and I do all the work today on camera and with our microphones, and you're in listen only mode. Although we would appreciate you participating and being engaged in a couple different ways. So we do have the react feature at the top, that little smiley face. So you can always click on that and you can be happy, you can give a thumbs up, you can do a surprise face. Now I'm kind of glad there's no thumbs down. I guess we can't get any negative feedback, which is awesome. So feel free to use those react buttons. We are also going to have 3 polls throughout the session today, so we encourage you to participate in those polls. They are completely anonymous. We don't know who's saying what. And then with regards to the chat, we love questions coming in the chat. So if you have a question about any of the content that we're talking about, feel free to type it in. We've got Jessica and Tanya are kind of monitoring the chat. I will as well. Some questions we may answer in real time as we're talking about that topic. Others we may wait till the end if it's slightly unrelated. And if we don't have time to get you an answer, or if Teresa and I don't know the answer off the top of our heads, we promise to get back to you. So there may be a Q&A that's sent out after the session, just to wrap all of those questions up in a nice little bow and make sure that you're not left high and dry. So that is typically our process for questions, but feel free to put anything in the chat throughout the session and it will be monitored. Okay, so some accessibility features for your viewing pleasure. You can turn on live captions. So there are 3 dots at the top of the screen across that banner bar. If you click on those 3 dots, there's a few options. You can turn on those closed captioning features if that's your preference. You can also view this in full screen mode. That is the 4 quadrants view icon at the top. It will make the slides bigger. So some of the slides, especially when it comes to the legislation, the text might be a little bit small. Again, if you want to read it all, that's fine. You can increase the size of the slides. If not, then just leave it as it is and you'll be able to participate in all of the chat polls and everything like that. And you can go back and forth, whatever you need. So our goals with these safety connections, we really just want to provide information. It is an opportunity for us to put information out there that we think is relevant to different sectors and different workplaces. Working with the ministry on these sessions, specifically Teresa, is always fun too, to get a different perspective and sort of, it's not just us sort of interpreting and trying to, figure out legislation in the Occupational Health and Safety Act, but to hear right from an inspector is always so beneficial and such a great opportunity for everybody in the session. And I always learn a ton as well. On that note, though, I do just want to say, I know we have a few people from out of province, which is fantastic, and out of the retail sector, which is what this session was geared towards. Everybody is more than welcome. It is a great information sharing opportunity. Just know that the legislation that we're going to be focusing on is Occupational Health and Safety Act for the province of Ontario. So again, doing investigations really is, relevant to all sectors and all jurisdictions. But when we talk specifically about legislative requirements, it is specific to Ontario. Okay, so our agenda today, and I talk really quick. Yes, sorry. Please, Teresa, jump in.
So just because you're on there and I know what workplace you're from doesn't mean the Ministry of Labor is going to come and inspect you if you have comments. That it's not how it works. So just so you're aware, if something comes up and you're like, oh gosh, I shouldn't have said that, we're not gonna follow up. Okay, so feel free to speak out there.
Perfect. Thank you for that, Teresa. Yeah, this is like one-way sort of information sharing. You get to ask all the questions and participate with no concern that, Teresa's jotting down names of organization is going to go pay them a visit. Like, it really doesn't work like that. Yeah. So thank you for clarifying that, Teresa.
And I have been freezing in and out, so just so you know.
Yeah, no problem. We'll make sure if you just stop talking all of a sudden, I'll just jump in and keep talking, because that's what I do. All right. So our agenda for today, we are going to touch on what are the legal requirements for investigations. And while we're on this slide, I also just want to be really clear. I don't want it to be confusing as we go through the presentation for the next hour, 20 minutes or so. We are really going to focus on harassment investigations. The legislation is slightly different. There is a sort of added level of complexity. We will focus at the very beginning that you have to do workplace violence investigations as well. But as far as all the best practices and getting into who gets the results of the investigation, all of that, we're really focusing on harassment. So the titles should be clear about, is this slide related to violence investigations or harassment investigations? So just keep an eye on that. And if you're unsure or we are muddying those waters a little bit, please just chime in the chat and ask for some clarification. And, we'll be happy to do that. We're going to talk about the process for conducting investigations, what to inspect from an inspector, if they're coming in, if there was a complaint, whether it was an anonymous complaint, what to expect when they come on site related to harassment specifically. And then we're going to talk about some best practices for doing these investigations. And then at the end, we certainly hope to keep some time for some Q&A, and we'll provide you with some resources.
Yeah, and the best practices are, they're not provisions in the legislation, so we wouldn't enforce that best practice. We would just enforce the provisions in the legislation.
Yeah, okay. So our first poll question is, harassment complaints have the same investigative procedures as workplace violence incidents? True, yes, no, or unsure? Go ahead, and again, this is completely anonymous. Just want to see where everybody's at and their thoughts around the requirements here. Okay, so it looks like we've got majority yes, that it is the same investigative procedure. Teresa, do you want to chime in on this?
So it's kind of a tricky question. A lot of employers, when they put their violence and harassment policies and programs together, they do it together. But there are different requirements for harassment than there is for workplace violence incidences. So the biggest one being is when an investigation is completed for workplace harassment, there has to be written outcome letters to the alleged harassee and harasser once the investigation is conducted. There is no requirement for that under violence incidences.
Perfect.
It is really confusing. It's confusing legislation because they're both administrative, which means, do you have a policy? Do you have a procedure? Do you have a program? Have you done training? That sort of thing. So hopefully today we'll be able to tease out some of those differences for you.
Absolutely. Perfect. Thank you. Yeah, so I guess to be specific, the answer to that poll question is actually no, that the procedures are slightly different because the requirements are different under the legislation as far as, what you do with that information, who receives, the results, how those are communicated. So we're going to get into that in a little bit. Now, I know this is really tiny, even on my screen right now, and I've got a big monitor. We just wanted to make sure everybody's clear that when it comes to doing violence investigations, there is a requirement under the program contents that have to set out how the employer will investigate and deal with incidents or complaints of workplace violence. So there is a legal requirement that, your program has to contain how you're going to deal with these complaints for violence. That's specifically for violence. And again, that's under section 32.0.2, subsection 2. Yeah, it's tiny. I know. I apologize. Okay, so now for workplace harassment investigations, again, legal requirements under the contents of the program, which were a little bit more sort of prescriptive in nature. So it does talk about, maintaining some privacy, confidentiality, the disclosure. It talks about how we're going to communicate the results of the investigation. Those are all requirements under the harassment legislation. Anything else you want to add about this piece, Teresa?
No, that's
Pretty
good.
straightforward. Okay.
It's right out of the legislation, yeah.
Yeah, and then we're still on harassment here. So there are duties under section 32.0.7. So it talks about specifically related to the investigation that it has to be conducted into incidents and complaints of workplace harassment that is appropriate in the circumstances. We're going to talk about what that means because that's very gray. Like what your definition of appropriate in the circumstances might be very different than mine. So we're going to talk about what that means and how we can kind of interpret that. And then the worker who has allegedly experienced harassment and the alleged harasser, how they are communicated with the results of the investigation and any corrective actions that have or will be taken. So that is a requirement that the employer communicates those results to both the alleged harasser and the individual, the worker that has allegedly experienced the harassment. The last piece at the bottom here is the results of a harassment. This is harassment specific. I want to be so crystal clear here. The result of a harassment investigation is not considered an occupational health and safety report. That is specific to harassment. That does not exist under the violence. And I'm going to pass it over to you. Explained this so nicely to me earlier, Teresa. So I'm going to maybe let you just explain the difference between how, the results of the investigation for violence or other safety incidents, how it's different for harassment investigations.
Right. So with workplace harassment, okay, you can't be providing, when the legislation first came out, folks in joint health and safety committees were requesting copies of the investigation. So they could read the investigation, see the investigation, see the letters. You don't do that. The investigation itself is something that, let's say you have HR do it, and there is a written outcome, whether it fines for it or it doesn't fine for it. Those letters go specifically to those individuals, the harasser and harassee. So that's it, that's all. Those letters will say something to the effect like, based on the legislation for workplace harassment under the Act, we find that workplace harassment didn't occur in the incident that occurred on June 6th, June 8th, June 12th, whatever like that. Workplace violence, there is an employer duty to provide reports to the Joint Health and Safety Committee. You want to go to this one?
Well, okay. I think this ties into what you're talking about a little bit. So okay. I'm going to let you take this one. Yeah.
Okay. So for workplace violence, there's a requirement for under 52.1. So you'll see it. And a lot of folks miss this. A lot of employers miss this. If a person's disabled from performing his or her own work, usual work or requires medical attention because of an accident, explosion, or fire, or incident of workplace violence at the workplace, but no one dies or is critically injured. Because of the occurrence, the employer shall within 4 days of the occurrence give written notice of the occurrence. Okay, this does not come to the Ministry of Labor unless an inspector wants you to do that. This just goes to the Joint Health and Safety Committee and the trade unions for violent incidences. So that expectation is you're going to provide that to the Joint Health and Safety Committee. They're going to see it. They're going to make recommendations, that sort of thing. This is not applicable to harassment. Is that what you wanted to?
Yeah, absolutely. So I think what's really clear is like if you are on a Joint Health and Safety Committee or your committee is asking for the results of a harassment investigation, and they say that it's a requirement like under the notices section or under the legislation to provide those results to the committee, that is not true. So investigation reports can be considered reports for other safety incidents, but not for harassment. It is very different, and there is sort of that stipulation, and it's not really a gray area to me. Like that previous slide makes it pretty clear that the results of a harassment investigation is not considered a report and does not need to be shared with the committee. And there's a lot of reasons why that makes sense, right? Like from a privacy, confidentiality, we need to protect some of the people that might be involved in that, including, the person that has allegedly been on the receiving end of harassment.
So I had an incident, if you want to hear examples, where early on in the legislation, when it came out, an employer, like it was brand new legislation, they actually presented the investigation results and the outcomes to the Joint Health and Safety Committee. In there was a list of witnesses and what they said. So then what happened was those witnesses ended up getting harassed by other people. So this investigation just kept rolling and rolling and rolling. So just remember, just do what you're required to do, follow the provisions, and you should be okay. But the incident for workplace violence, I've only ordered one employer to provide workplace violence incidents to me as they happen, but it was a youth justice location. Is that clear?
Yeah, makes sense to me.
Any hands up, fingers up, or thumbs up if we're clear? If there's questions, just put it in the chat.
Awesome. Okay, I see some thumbs up. That's good. Good sign. Okay, and we can come back and again, we touch on this a little bit later as well when we talk about the results of the investigation. So again, if by the end of the safety connection, there's still some questions around sharing of the results of the investigation for either violence or harassment, and please remember that they are separate. A harassment investigation is different than a violence investigation, right? Because there are different requirements.
You can physically use the same template, but it's the outcomes that are different. Absolutely. That's what I see often.
Yep. Okay, so I'm just going to quickly touch on why it's so important that we're having this conversation. So workplace violence and harassment investigations are incredibly important to investigate and to investigate well and put the time and energy and effort into doing this investigation. First of all, there are legal requirements that you have to do this. Okay, we've already touched on those. The other concern is that these incidents are often underreported, and that is a fact. Incidents of harassment and incidents of violence or threats or attempted violence in the workplace often go underreported. People accept it maybe as part of their job, or maybe the reporting mechanisms are complex and cumbersome and they don't want to waste people's time. Maybe they're worried about reprisal, or that, they're worried about job security for reporting these types of incidents, especially if the alleged harasser is in a position of power or authority to grant or deny a benefit. Those types of situations really are difficult for people to report. So we want to make sure at your workplace that you have this culture where you're encouraging people to report. You truly do want to know when these incidents happen, right? So that you can take the necessary steps to investigate and put controls or corrective actions in place. Because while someone may not, might not result in a WSIB claim, or someone might not need a Band-Aid or need to go to the first aid room, these types of incidents, when they happen in the workplace, absolutely have a lasting impact on workers and on their mental health and on their ability to show up and perform, and can affect their quality of life. So it's really important that we do take these seriously and that individuals, workers, feel supported and are encouraged to report. Through reporting and doing a proper investigation, you're being provided with an opportunity to identify different hazards that exist in the work environment. So again, I know this is retail focused, right? We're supposed to be focusing on retail today, which means that there is a huge percentage of people interacting with the public, right? And sometimes the public and those interactions can be the hazard. And you may be like, yeah, well, Christy, there's not much we can do. We have to interact with the public all the time. They're always going to be a hazard. That is true, but maybe you could start looking at what your processes are, what processes you have in place that are causing people to become escalated and frustrated and put your workers at risk of violence or, you know, even internal harassment, those types of things. But without investigating and getting to the root cause, you're just accepting it as what it is, and that's not okay, right? We need to, again, try to minimize these incidents. Okay, we want workers to feel like their safety is a priority. Yes, of course. And we know if we saw like a slip, trip, fall hazard, or if there was a chemical hazard or air quality hazard, we'd take those complaints or concerns seriously. We would investigate them and put controls in place. We want violence and harassment to be seen in the same vein, that if these incidents are happening, it absolutely can have a negative impact on worker safety and their sense of safety in the workplace. So we need employees to feel like, you know, their safety is our priority. And I already mentioned this, but, you know, working in an environment where there are high levels and high incidents of workplace violence and harassment can absolutely have a negative impact on worker mental health. So if you have workers, again, that like go home at the end of the day, maybe they're short with their significant other, maybe they can't sleep at night because they're being bullied or because someone yelled at them and had a really, you know, negative customer interaction, that absolutely weighs on them. That is the workplace causing harm. So we need to know about that. We need to investigate it, and we need our workers to feel supported and like we're properly addressing their concerns. Okay. Moving. Anything, Teresa? Are you good if I move on?
No, our legislation does, I understand from a WSPS perspective, and you have courses on this and stuff, but the mental health component of that is not legislated for us. It's really, do you have a policy? Do you have a program? Have you done training? If you had an incident, have you provided an outcome, a written outcome? So not to make light of that, it's just not in our legislation, but I know that this is something that WSPS brings forward.
Yeah, and I talk about it because it's near and dear to my heart. And I talk about like workplace mental health all the time. So I'm just inserting it in there because like it is important, even though it's not legislatively, you know, the mental harm aspect. You're not going to see mental health or psychological safety in the Occupational Health and Safety Act. It is not there. It is avoided. Not avoided. It's just not in the legislation. But it doesn't mean it's not the right thing to do and a reason to care and to put some effort into doing these investigations. Okay. So our process that we want to talk about, we're going to get into sort of who should be conducting these investigations and you know, this idea of competency and who's the right person and why that's important, what to include in the investigation, who receives a completed investigation, the aspects around privacy and confidentiality, and, you know, we can touch a little bit on this. And I think this is where, you know, maybe Teresa, when you and I talked about it, the integrity of the complaint. So Teresa and I spoke about this, and we know, we're not naive, like we know that sometimes people bring forth a complaint of harassment and it is not harassment. And we might not even think it was brought forward in good faith, right? Like maybe someone's just trying to get somebody else in trouble because they don't like them, or they were asked to do a job that they didn't want to do, or they were held accountable for some performance issues and now they're claiming harassment. But, you know, bottom line is if you get a complaint, you should investigate it. And the findings might be that, yes, this did not constitute harassment. I'm going to pass it to Teresa because I know you had some thoughts on this as well.
Yeah, it's difficult when we get them. I will say that a large portion of them can, the integrity might not be there. But what I would say is, remember that when people put these complaints in, some of the, if there are mental health issues with a complainant, they really believe it. Like, there is no, talking around it. When we get a complaint and we have a conversation with the complainant, we set out what's required in the legislation. So we kind of set the expectations. And all the time that I've been doing this, I really feel that an investigation being done is probably the best thing for the employer to do, irregardless. Some of these can be pretty messy. They can involve human rights, culture, sexuality, all those sort of things. But if you focus on the complaints that are workplace specific, the complaint that they're bringing forward, and define your investigation as it relates to our legislation, I think at the end of the day, it's required, but it's really the best thing for the employer to do.
Yeah. So when in doubt, and you may, as soon as a complaint comes forward, feel like, oh, this is not in good faith. Like this, we're going to find that there's nothing, that this doesn't constitute or meet the definition of harassment. Still go through the motions, do the investigation, have an open mind, make sure you document everything. And you may find, that the results are sort of what you originally thought, or maybe it's not. Maybe there was more going on than you originally realized. So, go through that process and make sure again that it's all documented. Okay. So who should be conducting? Okay, we're specifically talking about the harassment investigation here. So depending on the circumstances of the incident or the complaint, a harassment investigation may be carried out by someone in the workplace. So it could be a manager or a supervisor or a member of the human resources or HR team. What's important, obviously, when we talk about manager and supervisor and even HR, it's really important that the alleged harasser is not the person that's involved in carrying out the investigation, right? It has to be this idea of impartiality, that someone, that's not involved, sort of more neutral, is conducting the investigation. It could be someone in the organization. It could be from another location or from corporate head office. I'm sure, for a lot of individuals on the call right now, you may have head office or, whether it's Loblaws or other companies, retail.
Uh-oh, she froze. Okay,
froze?
So I think you froze.
Oh.
So go back to point 2, someone in the organization. That's where we lost you.
Oh, sorry. Oh, that's weird.
Okay.
And I was still moving on my screen here. Okay. So someone in the organization. So if you are part of like a larger corporate structure, if you have individuals at head office, they may be, or even different locations, they may be the ones that are conducting the investigation. It can be someone associated with the workplace, right? If it's a franchise, you may have a business association, those types of things. Or someone from outside the organization, right? Maybe you are going to contract this out or hire someone to do the investigation, or a human resources professional, even a lawyer, depending on the complexity and whether you have the skills and abilities and resources available internally to manage it. Anything to add there, Teresa?
Yeah, so I often get, we can't afford that, to have a lawyer do it, or an HR professional, or a licensed private investigator. There are a lot of other folks that can do it, as long as they're competent. They understand and they're impartial. So as long as they understand the legislation and they've done some before, we would look at that as appropriate. Where it gets to be a problem is if you have a mom and pop shop, and mom and dad and the children run it. There's like 4 workers, and they're complaining against one of the family members. You wouldn't be able to have anybody in that family investigate it. That wouldn't be impartial, right? So you would have to look outside your company to see if there's somebody who has a competency to do it, training, knowledge, and experience.
Mm-hmm. Yeah, and I mean, I'm sure there's, it can be relatively costly to get external or third party, someone outside of the organization, to do an investigation. But the risk of having someone internally that's impartial or doesn't have, the qualifications to do the investigation and it's not done properly, there can be costs associated with that as well. So you really do want to sort of just make sure that whoever the person that is doing these investigations at your organization, get them a bit of training, right? Like, again, the legislation does not speak to what that has to look like. There's no licensing for being a, you know, a skilled or appropriate investigator, but you want to show that there's some level of competence and impartiality in the person that you're selecting to do the investigation.
And if I recall, folks who do third parties, some will offer a flat rate and some will, they've gotten very good at this, a rate on how many witnesses they, you know, have to, how they have to look at it, how many witnesses they have to interview. Some, you know, so there is a really, really big cost to it. You know, I try and have conversations with workplaces and say, you know, a third party might be your best bet. It doesn't have to cost you a lot. Is there anybody who that you can think of that can do it? And a lot of times there's only been once, and I know we'll talk about this later, that I had to order a third party investigation. It doesn't happen very often. So since 2016, I've had to do it once. And then I've looked at some that they've sent out to lawyers, and they're like 20, 30 grand. I don't even know how that happens. So just a few thoughts there.
Okay, perfect. Thank you. So there is this term in the Act that says appropriate investigation. It says an appropriate investigation, and this is actually full credit. Like, this text is from a guidance document that was published by the Ministry of Labour, Immigration, Training and Skills Development. It is available free on their website, and we will provide a link to it in the resources. And it's a great document that goes through sort of what some of this terminology, how to interpret some of it. So we have pulled some content from that because, right, we want to make sure that we're speaking the same language and on the same page. But an appropriate investigation would be timely, fair, and address all relevant issues. Again, we can even interpret like what is like timely, what is fair. Yeah,
taking reasonable precautions. It's we refer to this document for appropriate investigations. So sometimes we have complainants call and say, they did an investigation, I don't like the outcome, I don't think it was appropriate in this circumstance. Okay, so then we would go out and I would just for the record, Ministry of Labour does not look at the investigation. We don't do the investigation. We don't determine the outcomes. Can't really change an outcome that's been determined by an investigation. But what can happen is, you know, I would go in and go, okay, so I know there's 5 witnesses. Did you interview all 5 witnesses? No, we only did 4 because that other witness is best friends with the complainant. And you're like, nope, right? Go back and have a conversation. So if witnesses aren't interviewed, or that's really my biggest one, is where they skip people because they feel like that person's not going to be impartial. The reality is to follow that thread through.
Okay, perfect. Yeah. So when we'll talk about timely, like the legislation does not say that like all investigations need to be wrapped up and done and results communicated within 30 days, 60 days, 90 days. That doesn't exist. There is no specified timeline, right? But the idea of being timely, right? Like, and Therese, you mentioned this to me this morning when we were chatting, like if there was a complaint, a harassment complaint, and nothing had even been started, nobody interviewed, nobody even starting to investigate, and it's been 3 months, like that doesn't seem to be appropriate, right?
There would be an order. If there is no investigation, there would be an order with our prescribed timeline.
Yeah, perfect.
We would put a time order in it.
Okay, perfect. Yeah, and then the order does have like a date, right? If you've ever received an order from the ministry, there is a date, like a comply by date that would be listed. So that would be like to start the investigation. So fair and address all relevant issues. Okay, so Teresa touched on all that. There is like, we need to consider that this is a case by case basis. And I'm sure Teresa can appreciate that too. Like, no harassment complaint and investigation is going to look the same. These are very complex issues. There's personality issues. It is not just the same as like looking at a piece of guarding on some equipment and saying it's either there or it's not there, or there's still a risk or there's not a risk. Like, I know guarding can get complicated too, but we're dealing with people and personalities and perceptions of situations and intentions. So it is complex, right? And some of these things do take time, and it does take time to do an investigation properly. So some complex investigations could include not just a review of the details of the incident, but any relevant documentation. And you can see at the bottom there.
I have her freezing again. Do you guys have her freezing again?
Am
Can you get a
I?
thumbs up? Or no?
Nope, she's not frozen for me.
Oh, it's a Teresa problem.
Thank you.
Sorry. No, we've had a few different sort of technical issues. I'm just gonna keep.
So you're freezing to me, but nobody else.
Yeah, yeah. That's
so
odd.
weird. That's odd. That's really odd.
Yeah. Well, okay.
Where did you get to?
I'm talking about documentation.
Yes.
So yeah, when you're doing the investigation, like some of the documentation and relevant information or evidence, it can be not just like conversations and witness statements. Sometimes there are emails, sometimes there's team meeting chats. There could be notes that have been, provided, or different documents, photos, text messages, videos, all of those things, right? Even if you have CCTV, you might want to be able to pull up a camera for investigative purposes and see what that interaction looked like and if it matches sort of different statements. We want to separate witnesses. Like, you don't want to have all the witnesses in a room together when you're interviewing them. Like, that should be done individually, just because sometimes, you get into this sort of group think, or people hear other people say things and that changes their perception or memory of a situation. So you do want to be sort of very careful about how we treat witnesses and make sure that they're interviewed separately from each other. We also have, you want to make sure at a minimum you're interviewing the worker that's alleging the harassment and the alleged harasser. Quick note on language here. And Teresa and I also talked about this morning. We had deep conversations this morning about harassment. It's great if your program and policy uses the same language that is in the Occupational Health and Safety Act. So some organizations use terms like the complainant and the respondent, or the alleged victim or the perpetrator. The Act is very, uses language around the alleged harasser and the worker alleging harassment. So again, there's nothing that says you have to use that terminology. That's what we're sort of sticking with here. But consider, again, just having that appropriate and consistent language.
So what I just wanted to say, you were talking about witnesses. There have been occasions where an individual has called and said, I gave them a list of 6 witnesses and they didn't interview 2 of them. So then I call the employer, talk to the employer, go, did you interview all 6? Well, we interviewed 4, 2 refused to participate. You can't do much about that, right? You just document it that Jane and Bob have chosen not to participate in the investigation.
Yeah.
Do the best you can.
Yeah. And I've also, again, having interviews and speaking to people is the best option. Sometimes people are more comfortable writing their statement down and what they witnessed, and accepting a written statement can also be appropriate if they don't want to sit down and have a one-on-one conversation. Like, some people aren't comfortable, or, even if English is a second language, or they're worried that something they're going to say it will be misinterpreted. Yeah. Make sure that, like, if you are getting a statement from someone, that they have an opportunity to review it and agree or disagree that it's an accurate reflection and representation of what they're trying to say. So it can be that they choose to write down a statement and provide that to you, or you're summarizing that conversation, writing it down and asking them to ensure or to sign and make sure it's clear and that it reflects accurately what they were trying to say.
That's really a good point. That's a really good point, Christy. I know that some unions have it in their collective agreement that that a steward has to be present during the investigations. Now, not all workplaces are unionized. So that point is really good. Again, it's not in the legislation, it's not prescribed, it's not a provision, but really at the end of the day, we do want to find out what happened, what's the truth, what's the issue, right?
Yeah, absolutely. There's a question in the chat. Maybe this one's for you, Teresa, but what can you do if the person alleging harassment doesn't want to participate in the process?
Well, that happens a lot. Okay, so this is if somebody puts in a complaint to the Ministry of Labor, and let's say I call the Ministry of Labor and I say, Christy's been harassing me. My name is Therese Bowen. I don't want to give my name. She really scares me, that sort of thing. Then all we can do as a ministry is go in and we would call this person. And we would say, look, if you don't give your name, that's okay. But all we can look at is, do you have a policy? Do you have a procedure? Do you have training? Do you have a program? That's all we can do is review the administrative documents. In order for us to go out, you have to give your name has to be available to go to the employer and say, this person is alleging workplace harassment. That's the only way, is we have to have the name, because how else would you we don't investigate it. How else would you address it as a Ministry of Labor inspector? So they have to give their name. We do speak to them. We make multiple calls to people. Sometimes they don't call us back, and we try multiple times, and 1 week here and there. And if we don't hear from them, then we'll go in and we'll look at the written measures and procedures. And then sometimes that person will call back and go, you didn't tell them. Like, oh, you didn't pick up my call. Like, this is how we're required to manage it under our policy and procedure. So that does happen. So if they're not prepared to give their name to the ministry for an investigation, for a complaint, then we can't help the employer and say, oh, it was an investigation for so-and-so that you needed to do. Does that make sense?
Absolutely.
Otherwise it's just an administrative review.
Yeah. Yeah.
We
100%.
will try and contact the person multiple times. And there's sometimes that happens too, that a worker calls in and they put a complaint in, they go, yes, we have a policy, we have a procedure, and they've done an investigation. They've provided the written letters, but I'm not happy with the outcomes. I can't change an outcome, add an outcome, that sort of thing either. So if they're not going to participate in the process from the start, it's really hard to look at it from a legislative perspective for that individual. That makes sense?
Absolutely. And even if the ministry isn't involved in this idea of sort of anonymous complaints, and it's within the workplace, and some workplaces have different mechanisms where people can, reach out to HR anonymously, or, with concerns or complaints. Even internally, you can't investigate a complaint that you don't have names for. Like, that's impossible, right? To do a proper investigation. And I understand why some people might not feel safe putting their name to a complaint. That speaks to a larger issue around culture in the workplace. If they don't feel safe or comfortable putting their name on that complaint and bringing it forward, you may start to ask the other question, but what is going on in our workplace where people don't feel comfortable bringing these concerns forward and sort of owning them? And like, do they not feel like they're going to be supported? Do they not feel like they have job security? Do they feel like they're going to be reprised against? Any of those reasons why people feel the need to bring up these concerns anonymously speaks to a larger cultural issue, I think.
Yeah, I think for Lorraine in the chat, so if the person comes up to you and says, look, Bob's harassing me, but I don't want to participate, I would at least sit down and take some notes where, the person, you can say in the notes, we were aware of this allegation. We have met with the complainant, the alleged or the harassee. See, we were doing this all this morning. And they have said that they do not want to participate, and, you know, they can come back at any time if they want to follow through. We often have people call, and once they find out that they, yeah, give my name, go, you know, go get them, that sort of thing. And we explain the process, then they kind of go, yeah, no, never mind, I don't want to do it. So it can happen to the employer, and it can happen to us as well.
Yeah,
where they pull back the complaint. And then what we say to them is, look, if you change your mind later on, then call the call center back, and we'd be happy to see if they have a policy program, training, that sort of thing. Does that answer your question, Lorraine?
Let Lorraine answer there. I'm going to move on. Oh, perfect.
Okay,
awesome.
Good. Thank you.
Good. Okay. So some of the things that should be documented, and when we say document, like this is in writing, right? Like it is important that, you know, not just to demonstrate this idea of due diligence and like you're doing a proper investigation, but it is important that we document these things effectively. Sometimes these complaints, like if there are multiple complaints against one individual or whatever your corrective actions were, and the, you know, the outcomes, and this person is, you know, the alleged harasser again, you want to have all of this documented so you can go and look back at it. What it should include is the names of individuals involved, the dates, what the complaint is, details of the incident, and being as specific as possible. Notes from any interviews or meetings that were held as part of the investigation. Any other associated documents or evidence, again, that can be emails, text messages, things like that should also be included. The full investigation report should be documented, as well as any actions taken as a result. So the outcomes, right? Like the outcomes, did this meet the criteria? Was it determined that this was workplace harassment or workplace sexual harassment or not, right? And then communicate those results of the complaint and in the investigation. Anything else here, Teresa, around the documentation?
Not just a thought that kind of popped into my head while you were talking. So this is a retail presentation, but just so you know, we have different programs like healthcare, mining, industrial, and construction, and this applies to those programs, and they can be fairly tricky. You know, as a result of trying to get a hold of people. So we do understand that there are some challenges in getting hold of people and witnesses. So this is why the documentation is so nice. That you could say, identified witness, Christy Cork, email sent on this day, no response, registered letter sent, you know, that sort of thing. So you can, at the end of the day, if this goes somewhere, and I don't mean with the Ministry of Labor, sometimes these folks hire lawyers, or there could be a parallel investigation with the police, or there could be a there could be an investigation with human rights. You have what you've tried to do. So documentation is really important.
Yeah. And I think that actually ties a little bit to Brenda's question in the chat around what are the requirements if the employee is no longer with the organization and they were the alleged harasser. Makes a complaint about it. Yeah. Okay. So there's a couple thoughts here, and one that's also in that guidance document on the Ministry of Labor's website is around, you know, if the alleged harasser or the perpetrator of workplace violence is someone external to the organization, then this requirement to like share the outcomes of the investigation with that, you know, non-worker person, that doesn't exist, right? Like you don't have to communicate the results of an investigation with a customer that came in and was the alleged harasser. And I think it would be similar if that individual was no longer part of the organization, you wouldn't have to share the outcomes of the investigation with them.
Christy, I am working in the field. Can you guys just carry on for a minute?
Yep, absolutely.
Thanks.
Yeah, so the alleged harasser, you can't force someone that doesn't work for your organization to participate in that investigation, right? Like if it was a customer or an ex-employee, those types of things, like you no longer sort of have any influence over their involvement. Okay, but you'd still want to investigate, like you still want to do the best you can to gather information. If you give them a call to get their side of the story, if they refuse to participate, you really don't have any other sort of means of forcing them to, even, you know, internally, you can't force someone to participate. Okay, our next poll question: can the outcomes of a harassment investigation only be verbally communicated to involved parties? And while you're answering that around this verbal communication, I'm just going to go back to Brenda's last sort of comment there, that you did an investigation mainly in the event that the alleged harasser had attempted to return to the company. And I think that's completely appropriate. No matter what, you want to take the complaints seriously. You want to do the investigation. Whether it is someone that's no longer with the organization, there might be some controls around, you know, not allowing this person to re-enter the space, again, depending on the nature of the workplace, or at least communicating and have an eye open knowing that this incident happened. Okay, so can the outcomes be communicated verbally, only be communicated verbally? And most of you got this right. They do have to be communicated in writing. So, and when we talk about involved parties, so this is the worker that is alleging harassment and the alleged harasser. We do have to communicate the outcomes, the results of the investigation to both of those parties in writing. Here is, you know, again, from the guidance document. So employers must ensure that the worker who was allegedly harassed is informed in writing about the results of the workplace harassment investigation and any other corrective action that has or will be taken as a result of the investigation. And it must also be provided to the alleged harasser. So it's actually not enough for the employer just to say, yep, we found that it was or wasn't harassment. That's not enough, right? We also have to share any corrective action that has or will be taken as a result of the investigation. So what is the employer prepared to do to ensure that this doesn't happen again, or that there is some corrective action in place? That also has to be communicated. And like we mentioned, you know, earlier on in the presentation, but just to be crystal clear on this, the results of a harassment investigation are not considered to be an occupational health and safety report. So we know that occupational health and safety reports must be communicated and shared with the Joint Health and Safety Committee. Those can be things like your workplace violence risk assessment, like an occupational hygiene study, other safety investigations, right, for slip, trip, fall hazards or noise hazards or whatever other hazards that you're investigating. Those are considered reports and they need to be shared with the committee or the safety representative. Harassment investigations are entirely different, and that is not the requirement.
Sorry about that.
Welcome
folks.
back. That's okay. This is perfect. This is your slide. I was hoping you'd be back in time to talk about this. Otherwise,
Okay.
I'd be really winging it. Okay. So what we can expect from a Ministry of Labour, Immigration, Training and Skills Development inspector. So Teresa's going to kind of just go through a few of these ideas, like under what circumstances would they come on site? What are they looking for? What could they order? Okay, I'm going to just pass it off to Teresa here.
Okay. So if we get a complaint that has an individual that wants to come forward, then what we do is we call that person and we just get basic information, then we set expectations. This is what we can do. This is what we can't do. We can't get your job back. We can't get your money. We don't do the investigation. That's the big thing that they're surprised about, is that we don't do the investigation. We don't do the outcomes. Okay. So then I would go into a workplace and I would meet with the worker rep and the manager rep of the Joint Health and Safety Committee and say, hey, we have a workplace harassment complaint. I need you to put me in contact with the best person who deals with this in your workplace. So let's say it's an easy visit and it's HR. So I just look at them and I just say, I don't need you right now, but I will need you to sign the report. You will not be getting any information about this individual, this complaint, nothing. So I meet with the HR person. I go, do you have a investigation. Are you aware of a complaint of workplace harassment from Bob Smith? Yes, we're aware of it. Excellent. Did you do an investigation? Yes, we did an investigation. They'll say that. We're in the process of an investigation. Or, you know, yes, the whole thing's done. I would say, did you provide written outcomes? Yes. And then we would kind of talk about not details, but just, okay, in my notes, what date did you do the investigation? What date did you send the outcome letters? Because I'm going to have to talk to that person again. Sometimes they're off work, so they're not even in the workplace. So that's what we do. Do you have a policy? We also do. Do you have a policy? Do you have a program? Do you have training? I always like to look at the training. So if it's a big place, I will ask them to show me the training records so that I can see if that person has had the training with the HR person. I want to know that the training has been done. So all that comes through. So if there's nothing, if there's nothing for me to write because they've done an investigation, they do the training, they have a policy, they have a procedure, they have a program, all that sort of stuff. Then I come back to the table with the worker rep and the manager rep of the Joint Health and Safety Committee. And I just say to them, an investigation is done. Outcome letters have been provided. That's it. That's all. These are probably the shortest field visit reports you'll ever see. If the person calls in and they want to remain anonymous, so we have anonymous non-verifiable complaints, which is where somebody calls the call center, they refuse to give their name or contact information. We call that anonymous non-verifiable. But they're saying, you know, this location doesn't have a policy, doesn't have procedure, doesn't do training. We would go in and do that administrative review because this is administrative legislation. If they call in and they give us our name, you give us their name, but they want to remain anonymous, then we go to the employer and we say, we have an anonymous complaint. I need to know if you have a policy, program, training, you know, what does your program look like? That's what we would do by protecting the anonymity of the complainant. But we can't get specific unless we know that there's a person associated with that where we can meet with the employer and go, Bob says. So that's kind of how we do it. So you can see orders for policies, for programs. Those would be time-based orders. I just had one last week, very sophisticated workplace, didn't send out a written outcome. And I said, and the HR man goes, yeah, I know I'm supposed to do that. I'm like, okay, you're getting an order to do that. Why didn't you? Well, it's really complex. And I'm just like, you're getting an order to release that, right? And then training. Are they trained on the policies and programs? Do they know what the definition is? Ministry of Labor is very definition focused. Doesn't meet the definition of workplace harassment. Are they a worker in that workplace? Is this a workplace? Those are things that the Ministry of Labor thinks about before they go out to these complaints. There is the ability for us to write third-party investigations. I think I've only written one. They are very, very expensive, so we try and meet and, you know, encourage them to have somebody who's competent to do the investigation. But they have been written. I don't believe there's been a lot of them, but they can be written.
We have a really good question in the chat.
Oh, okay.
And I'd like your thoughts on it. So is the employer required to share the specific corrective action, like there was coaching or a warning letter or they were terminated, with the alleged harasser, and I'm assuming the person that has been harassed? Or can you just share that appropriate action was taken?
I think you've got to get a little bit more detailed.
Yeah, me too.
So this is a really contentious point, right? Where that person who's put in the complaint needs to know that there's an outcome. If there's an outcome, if you've provided retraining of the harassment program, those sort of things. As far as discipline, you could put discipline, and I don't believe you're required to say 3 days at home, no pay. You know what I mean? Like,
yeah.
We did have one where the employer actually terminated a VP, and that wasn't enough for the worker, and that was provided in the outcome letters. So yes, you have to give them a little bit of something, but not super details. Does that make sense?
I think so. Like, as you were talking about the other stuff, I picked up my green book and I'm like, it's very specific that it says like any of the, like, it's not just like share that there were corrective actions. Like, I think it is, the intent is that it is more specific.
Yes. So, but if you have legal in your workplace, you could consult legal. But what I'd like to do, Christy, is let's put this, I know that there's been a lot of conversations with our legal and expectations and things like that. So just in order to be accurate, my expectation, again, if the worker was disciplined, I don't need to know it was 3 days. I don't need to know they, you know, what the discipline was. It could be a verbal, it could be a written, it could be a suspension, it could be a termination, it could be all those details. I don't need to have, me personally as an inspector looking into it, but I know that there's been a lot of chatter around that recently. So let me see, who is this? Sorry. So are you okay with us? I'm going to stand by what I said, but I'm going to, we'll let you know if there's been any changes in that. Is that all right? And we will get back.
Yeah, so it's a fantastic question. So this happened at the last Safety Connection as well. And if you participated in it, you would have got a follow-up email almost a week later with a clear sort of answer on one of the questions, because it is important, you know, specifically from Teresa's point of view, that like we don't want to mislead anybody, and we want to make sure that, you know, anything that you're going to base a policy, a program, or, you know, future communications or in these letters, that it is accurate, and that we're not just giving our opinion on something, but that there's actually people we can talk to that have like,
I would accept, like, again, we don't determine the outcomes. It really is the employer's duty to put what they have in process. I have seen the written measures and procedures of the policy or program that says to workers, a corrective action could be any of the following ... and may be written in the outcome letters. I've had employers refer to their legal department, and the legal department is saying, nope, this is all we're giving them. And so we don't necessarily get called in about the content, I think maybe once or twice of the letter, because here's the other thing, HR folks, if you put too much in there, you might get a complaint, right? It's this balance of what's to be provided, and it should, in my opinion, and what I've seen over the last 21 years at workplaces and since 2016, is detail is important in your policies and programs so that there are no surprises to your workers. Is that okay? So for the time being, yes, some detail, discipline would be fine. But here at the Ministry of Labor, we change our minds quite often. So I just want to make sure I know what the latest is.
Absolutely. I think that's fair.
Is that okay, folks?
Okay.
Is there anybody on the call that's had had anything like this happen to them before?
We see lots of thumbs up. People can't really chime in because they're all muted, but
no, I understand. Yeah. Okay. No, that's good. It just helps me. It helps me know.
Yeah. I think maybe our follow-up, when we do send out a follow-up response to this particular question around the outcome letter, you know, maybe we'll give you a little bit of information about exactly sort of what should be included and whatnot. And I think even Teresa and I did speak earlier about this outcome letter and sharing the results and being really clear on what is it that, you know, the determination is. Like, we're not, this is specifically related to occupational health and safety and definitions of harassment and violence. Like, we're not getting into human rights and things like that. Like, there could be other concerns that are related, but what we're talking about today is specifically safety legislation, right? Does that make sense?
Yeah, definitions, we're focused on definitions.
Mhm.
So here's the other thing too. I've had complaints where somebody has said, they told them I got disciplined and I was demoted and my pay was like it was too detailed. I, okay, I can't pull that back. We don't have any legislation for that, right?
Right.
Nothing.
Yeah.
And the legislation speaks to corrective actions, if any, and it doesn't give super detail of what that looks like.
Mhm. That's right. Okay. All right, we're gonna keep moving along here, but thanks everybody for chiming in and even the thumbs up. Like you have no idea. Like Teresa and I, sometimes it's like we're talking in cyberspace and we just hope there's people listening. So when you engage and like do those thumbs up and chime in the comments, like it really is really nice for us because we know people are on the other end and listening. Yeah, thanks, Kim. All right. So our next poll question, thinking again, being engaged. Is there a maximum amount of time it should take an employer to complete the investigation under the Occupational Health and Safety Act? So does the
Sorry.
act dictate the maximum amount of
Christy.
time? Yes.
Jessica had to hop off. She asked that I populate the poll, but it looks
Okay.
like I don't have access to it. Do you?
It's a great question. Let's see.
I'm so sorry. I thought I
can
did.
sure try. I can sure try.
I just
Okay.
thought I did, and I can't seem to locate it.
I think I do have it.
Thank you. I'm so sorry.
I have one that was closed. That's weird. I do not. I don't have this.
Create one really
We could
quickly.
we could just tell them.
I could just create it really quickly.
Wow.
Yeah.
Hi,
Okay.
Jessica.
Yeah, that's weird. I had the first two polls were in the thing, but
I think just because she hopped off that it disappeared.
okay. Shoot. Okay.
No, it's okay. I'm going to create it really quickly. Just give me 2 seconds.
Well, everybody can put a lot of thought into their answer for this one. Are there any, maybe while we just give Tanya a second to make this poll for us, any other sort of questions so far, or even again, if it's something you want us to dive into and provide in a follow-up Q&A after, maybe something still a little bit muddy, go ahead and like let us know in the chat. Oh,
I did
please
it.
answer from question on screen. I love it. Okay.
Real quick.
So again, if that poll popped up right in front of your screen, is there a maximum amount of time it should take an employer to complete an investigation under the Occupational Health and Safety Act? So true, false, or yes, no, or unsure. Okay. Thanks everyone for your patience. Appreciate it. Okay, so we are at about 53% are thinking false, like no, there's no maximum amount of time. Some people say yes or true, and a couple unsure. So Teresa, do you want to tackle this?
Oh, sorry, I got distracted for a second. No, there's no there's no legislative requirement. Although when you develop your program and procedures, right, a lot of employers will put 30 days, 60 days, 90 days. They'll put something in there as their policy. We don't enforce the policies per se, employers' policies, but there is nothing. I had an investigation go on for almost 8 months. It was complex, and I was just like, carry on, right? They had put some interim measures in place to protect the complainant, and then that sort of thing. I wouldn't suggest 6 months. I will say when we come in and there isn't an investigation, we'll probably give the employer, this is me personally, 3 weeks to a month. And again, sometimes it depends on timing. If it's a summertime and folks are on vacation, you can have that conversation with an inspector, right? If they go 2 weeks, you could go, okay, well, the person that we have off is, who's going to do that is off for another week. Have those conversations. The idea is we want you to do a good job. And an inspector can say no, but if you give some reasons why you might need a little bit more time, they may consider like a longer period of time for you.
Yeah, sometimes
That's just
asking,
me.
right? There's no harm in asking.
That's just me. Okay.
Yeah.
Other inspectors may have a different approach.
Okay. All right, moving on. This next slide is around some best practices to consider. So again, we want to be really clear that this is not content from the Occupational Health and Safety Act. This is not Teresa saying that thou shalt do these things. This is really best practices to sort of set yourself up for success, to help employees or workers feel supported through this process. So when we say the timeline should be reasonable in the circumstances, yeah, some do take a long time. Some might take 6 months or so by the time you get all the witness statements, all the documentation, all of that. Maybe you've got to ask IT to get involved and get some emails and things like that. But keep parties involved and informed. Like, don't just say, yeah, we're doing an investigation, and then it's been a few months and they've heard nothing. It's been crickets. They're going to really start to lose faith in the process and that you're taking the complaint seriously. So if you keep them apprised of the situation, keep them sort of up to date on what's going on, and that can really go a long way to help build that trust. The worker alleging harassment and the alleged harasser should be prevented from being in contact. This really does depend on the severity of the allegation. So if there is like a workplace sexual harassment or some pretty serious bullying that someone is claiming, consider reassignment of duties or finding ways to keep those two individuals from interacting pending the investigation and the outcomes. So again, it really does depend on severity. And I also just want to add, like, don't always make the person that is alleging the harassment, like the complainant or the alleged, person that's on the receiving end of harassment, be the one that sort of has to move shifts or change shifts or go off work or things like that. Like, really be considerate of both parties. There's a question, Teresa, is there a timeline for the time lapse of an event that a person can make a complaint?
No.
Like, this is like a
Okay,
statute of limitations kind of question.
Yeah, so you know what? I can't speak to pay. Suspension with pay, that would be more employment standards. That would be your legal advice, HR sort of thing. I will tell you, this is what I do. If I get one from like 3 years ago, you're kind of like, oh man. So this is where you're gonna not like what I have to say. That has to be a case by case basis because it depends on the complexity and severity, what's in there. I think the longest one I've ever done, folks are pretty on this. And it's typically, we will see later complaints when somebody was on WSIB and then it got denied, their claim got denied, so they have no way to have income. So they'll go, oh, by the way, 3 years ago I was harassed. It's my understanding, but I'm not sure if this is an urban legend. If folks are applying for unemployment, if there's a safety concern at work, they can get paid. So we get a lot of harassment on that. I'm not 100% sure if that's true. I don't know if it's an urban legend. So typically, if I had one come in from a year or more, I would sit down with our regional program coordinator and manager and go, what do you want to do with this? I'm not, very rarely, they're all fairly recent.
Yeah, and I do see the comment from Tammy in the chat that like both parties should be removed from service with pay during the investigation. And like, I think ideally, yes, but we also have to understand that there are a lot of workplaces that are very small, and the cost associated with having 2 workers go off work while receiving pay could be quite crippling for a lot of organizations and smaller workplaces. So we just have to be careful that, like, yes, well, some things may feel like the right thing to do. It might not be applicable in all circumstances. But again, just making sure and being sensitive that the person that is, the one that is alleging harassment is kept safe during this investigation process. I think that's the most important thing to remember. The employer does not need to hire someone externally to do the investigation. However, they should be able to remain impartial. So I did share earlier in the chat that guidance document, and it does talk about this idea of impartiality and what that would look like and how to demonstrate that as for the investigator. Speak to witnesses in a timely manner and not in a group. We know our memories are most fresh early on and when they haven't been influenced by others. So that's a good tip. This was one of sort of Teresa's following the thread of the investigation. Don't start your investigation with blinders on and say, I only need to talk to this person and this person. I only need to look at this because that was part of the alleged complaint. If through investigation and through talking to people and witnesses, you realize that there may be other parties or other individuals that were witness or have information, go and talk to them. Right? Like this isn't something that is always a straight line. Sometimes you have to sort of think a little bit outside the box, get a little bit creative and, you know, talk to anybody or get any information that you think could help you formulate the best outcome. I'm going back to a comment from Kim in the chat here, just so I know it can be very distracting if I'm reading from a slide and then going to the chat. So I'm in the chat right now. You can be proactive during this while ensuring everybody is kept safe and offer healthcare, mental supports, and possible training opportunities. Yeah, absolutely. If your workplace has like an employee and family assistance program, offering those types of supports to individuals that are involved can be very helpful. I mean, I don't really want to go down this rabbit hole, but what often can happen is if someone is alleging harassment and they're not sort of off work with pay during an investigation, sometimes people go off work on a short-term disability claim. That can get kind of messy, right? So we, again, just being transparent with the individuals involved and trying to wrap these up and do your investigation in a timely manner is going to help all workplace parties. Showing care and concern, absolutely. Like, show that you're taking this seriously. If someone comes forward to you with a complaint of harassment, that is not an act of bravery, but sometimes it's really hard for them to do that, especially if some of these behaviors have been going on for a long time. Maybe they're relatively new to the workplace, they're worried about job security. That can be very, very difficult. So just be really sensitive to that and take it seriously. Don't judge, be open-minded, listen. Don't presume that you already know what the outcome of the investigation is going to be before you start it, because that's not being impartial, right? Really follow what people are telling you, give the benefit of the doubt, right? Just be open to it. And
sorry, can I just?
Yeah, yes,
so
please.
I know Christy said these are best practices. They're not provisions in the legislation. So again, Ministry of Labor, do you have a policy? Do you have a program? Do you have training? Did you do an investigation into the complaint? Do you have outcome letters? That's it, that's all. Because it's administrative. We don't do the investigations for the workers. We don't write the letters, that sort of thing. It really is an employer-driven administrative process.
Mm-hmm. Yep. Absolutely.
I'm not as touchy-feely as Christy. I just have the legislation. That's all I have. So
I am not touchy-feely, I promise. Like, I keep my hands to myself.
Yeah. No, but these, like, I'm assuming these best practices, I mean, the one for me is follow the threads of the investigation is really important. But I think Christy does a lot of work with workplaces where this is really good advice from WSPS as to how to manage a situation like this. You know, if you come at it as, you know, unfeeling or whatever, you might get less information. But so these best practices are probably things that Christy has seen. Again, for Ministry of Labor inspectors, it really is just administrative legislation.
Yeah, absolutely. So yes, and that is fair. Like, I do a lot of work in the sort of psychological health and safety space, and some of these best practices are not legislated, obviously, as Teresa says, but they will help set you up for success and help build sort of a culture within the organization where people want to come forward, they feel safe, they feel psychologically protected. All of those are really, really good things. And you have an opportunity when people come forward with these very difficult concerns to foster that and to make people feel like, yes, their concerns are important. We're going to investigate. We're going to take the time and put the energy in, not just because legislatively we have to check these boxes, but because we really care about how your experience is at work, and we don't want you to experience mental harm in the workplace. So we are going to take the necessary steps to do a thorough investigation. That's more my angle, but yeah. That's why
Yeah.
we're both on the call, Teresa, because you got the non-touchy-feely stuff and I got the like,
No,
do
I
this.
don't want it to come across as unfeeling. We do get it, but we're restricted. Like, folks have to remember that the Occupational Health and Safety Act and associated regulations to programs, this is just minimal legislation, right? You can do way more if you like.
Mhm.
That's no problem. But we are really stuck sometimes with minimal legislation.
Yeah, absolutely. Okay. Well, I mean, on that note, we are coming to the end of our time. We've got a couple more slides here. Just, WSPS can help. Listen, we have tons of free resources. You're going to get a follow-up email after this session with some of those resources, and that includes, our workplace violence toolkit. There's, some other things in there around, policy, program, risk assessments, things like that. You can always reach out if you're looking for some help or support. We have more safety connections always, coming up. There is the Health and Safety Excellence Program. If you are interested in that, that's, putting some different safety programs and doing some work to be able to get rebates back from WSIB on your premiums. So that's something that's really great if you're interested in that. And then here are some of our resources that we're going to be providing to you after the session. Tanya has included in the chat her email address as well as mine. So again, if you have any other questions, and Teresa and I are in contact, if you have questions for her or I can't answer something and I need to reach out to her, we will make sure that we get some good responses that we're both sort of happy with sharing, because sometimes questions can be difficult. We don't want to misspeak or provide you with information that might be contradictory down the road or when you talk to someone else. So allow us, especially for that one question around, how to communicate those corrective actions and how specific and detailed, let us get back to you. We promise we will send something out with a response that we're happy with and that we feel comfortable with.
I just want to go, but I know what I would expect. I just want to make sure that nothing has changed in our policies. And that's what I'm going to do, is just kind of have a quick peek, because I know over the years there's been a lot of chatter around it. And I want to give you the best answer that I can. And sometimes that's tricky. So I just want to make sure I'm not giving you false information or expectations.
Absolutely.
We appreciate that.
Yeah, 100%.
So like I said, I'm going to connect with you ladies after the fact. I'll put that in an email, the question, just so you have it. When you get it back to me, I'll give it to Jessica and she will include it in the follow-up email. And to all the participants on the line, as I stated at the beginning of the call, these sessions have all three sessions have been recorded. And
those
Jessica,
WSPS people are frozen for me again.
Oh, you're frozen for us.
So. And we will have them. We'll have them on our website for you tomorrow or Friday, I think. But I believe we might also include a link to that in the follow-up email as well, just so everyone knows. Okay. Yeah. Thank you to you both. Really appreciate it. Really appreciate this.
And thanks for everybody that's joined, especially for all three sessions. Like, that's fantastic. And all of your comments and questions and engaging, and especially thanks to Teresa, like, getting someone, I know she's super busy. We don't need to get into details, but there's a lot going on, and to take the time to work with me to put the presentation together and share your expertise, we absolutely appreciate it.